but legally you cannot do. If the bank check from the date of the demise and the withdrawal that you done, if you done after the demise to this bank account, then you are open up to legal action. Sebab by right, once a person demise, all the asset must be freeze, even the bank account. You cannot go and simply withdraw. Like for example, husband pass away, wife the next day cepat-cepat withdraw all the money guna ATM. Cannot. The other beneficiaries that supposed to get that cash money will sue this person, because like the deceased already passed away, but then the transaction of withdrawal occurred after that. Who do the withdrawal? So you are open up to legal action. This is wrong. It's under criminal. It become another criminal action already. So cannot do that. You means that upon the demise of settlor, all the fund, all the money is being frozen. Credit card frozen, cash money dalam bank frozen. So all frozen until you get that court order for the executor to do the job. So if get court order, probate, executor do the job. Kalau LA, administrator do the job. Then only do the transfer. Without that, you cannot simply go and withdraw cash money, swipe bank, credit card, cannot. All must be frozen. But then trust fund, no. Upon demise, it's actually do the work is started. Do the transfer straight away. Tak ada frozen the fund account. Okay. So second, absolute right to the settlor on appointment of beneficiaries. So as for trust, we know if he wants to appoint anyone, no need to be family members. If he feels that he want to appoint someone non-family members as the beneficiaries, he can do so. It's based on settlor's wish. So he may have his own reason whatsoever, but settlor wish if he want to appoint that particular person as beneficiary, be it, we have to honor the trust deed and just do the transfer upon the demise of the settlor. But when it comes to will also still they have they can give to anyone. They can give to anyone that they want, provided they have to mention in the will they're going to give to this particular person what. So have to mention. But no will, there's no room to give to anyone. Means you have to go through your rightful beneficiaries. Okay, third, so it's an explanation. The settlor can appoint anyone as beneficiary. For Muslim, asset held under private trust fall under outside the settlor estate. So hence is not subjected to faraid distribution. If anyone here that joined my previous legal sharing, I do the sharing on faraid distribution. So as I mentioned previously, when it comes to trust doesn't involve faraid. So it means kalau katalah lelaki Melayu tu, dia meninggal, he pass away, the trust fund still operate as normal. But if let's say he only allocate, for example, 1 million of his asset in the trust fund, he has the remaining 4 million, no trust. This 4 million must be distributed by faraid. But this trust fund cannot be forced or pushed or to say that you must distribute it by faraid. So it's actually protected from faraid. So as we know, when it comes to Malay, faraid is a very different concept. The guy in the family will get more than the lady in the family. So trust is actually a medium for them to protect their asset. Third point will be confidentiality. So as I explained before, trust is a very private. So upon the settlor demise, the transfer to kin, direct to the beneficiaries. So when a private trust is created, all assets are held under the name of the trust. If let's say cash money, the cash money will be under the trust fund. Hence, settlor and beneficiary remains confidential. Upon settlor deceased, then the money will be transferred to the beneficiary. So unlike a will, when assets are distributed, it is done so to the intended beneficiary, discreetly and privately. Means compared to will, because will they have to read it. They if whoever that have experience before, when they have will, what they do is they will read it out. They will do a family gathering and do the reading of the will, so everyone will know who will get who. So when it comes to trust, no, it's a very private and discreet. Upon settle or demise, straight away do the transfer to the beneficiary. So then the fourth point will be professional management. Executor and administrator, I say that if none of them have a knowledge about this trust, about this asset management, estate management, uh, it'll be very trouble for them. They don't know, they don't understand the process, they don't see it, they don't picture it, why this must be done. They find it very difficult. But for trust, when it comes to you appoint a trustee, it's a professional management. So it can be done faster. With professional management, it's more secure. You can feel a relief that you know the trust fund has been professionally managed by the team. So last but not least, I think this is a point that is a good point. Protection from bankruptcy and creditors. So trust fund, like I said before, is protected from all these creditors and beneficiary. Will is not creditor proof. I mean, it's not, means it's not protected from creditor. Creditor still can access to the asset. But when it comes to trust, creditor cannot come in to disturb that trust fund.